Thanks for joining us today. This is our presentation about Section 1557, the anti-discrimination law and subsequent regulations that were enacted under the Affordable Care Act. I'm your presenter, Jay DeVoy. Just want to give everyone a quick orientation about this. This is something that's been very popular over the last few years, and as the title suggests, that the current administration has changed its focus in terms of the emphasis, priority, and direction of Section 1557. If any of you looked at the OCR's website regarding 1557 recently, you'll notice that it's had some changes. A lot of resources and materials have been removed. There's some specific guidance that was specifically rescinded by HHS earlier this year that we'll talk about in a little bit. But one of the most important things to note about the direction of 1557 is that it is not gone. It is still, in terms of the statute, on the books and kind of an integral part of the Affordable Care Act that I don't think will ever necessarily go away. But the rulemaking and the prioritization of enforcement are slightly different now than they were previously. And looking at the OCR's website now, there's a heavy emphasis on individual freedoms and liberties in healthcare. So while the prior administration had enforced the rulemaking that was done pursuant to the statute, in a way that focused on increasing health equity outcomes and bridging gaps in care, the current administration is focusing a lot more on individual rights and specifically emphasizing conscientious objection on religious and other grounds and focusing on the individual rights in healthcare. The common fault lines where you would likely see this are kind of predictable political ones, specifically about gender expression and identity issues and about termination of pregnancy. So I don't think there's any surprises there. This is not a political presentation, but given the manner in which 1557 has been expanded and contracted and expanded again, and now is in a period of kind of waning under the current administration, it is necessary to talk about these political issues in some way. So we will keep the commentary to a minimum, but want to just alert everyone that there will be some discussion about the ramifications of elections and what they have had on this rulemaking and the implementation and enforcement of this statute. Just a general disclaimer, this presentation is going to be made in very general terms about what the law requires, any kind of updates that we have to provide about it, and how it's being enforced currently. These are not tailored to respond to any specific legal situation or give anybody specific legal advice. If you are a current client or if you'd like to become a client, we're happy to speak with you about that, but this presentation isn't tailored for that moment. Relatedly, we are happy to answer questions. My preference is to answer them at the very end of the session. So if you can put a question in chat, my preference is to go over them at the end. Also, our team will collect those questions. We can respond to you separately by email. That would be an option as well for things that lend themselves to a longer discussion if one is necessary. But just so everyone's aware, if there are questions that happen, please, by all means, write them down, submit them. But just for the sake of covering everything we want to cover in the limited time that we have together, my preference is to hold them to the end to the extent possible. Just to go over what we're going to talk about, the history of Section 1557. A lot of these items are topics that we've talked about in the past, and you likely seen coming. We've been dealing with Section 1557 since probably the mid-2010s, when the first round of rulemaking was commenced during the Obama administration. It was walked back under the first Trump administration, was then expanded under the Biden administration, and now we're in a period where there's a de-emphasis of it consistent with other activities by this administration to de-emphasize focuses on equity and inclusion that were affected by executive order at the very beginning of this year, consistent with the turnover administration. Section 1557 is not the only anti-discrimination law that you have to deal with. It's important to be mindful of the fact that there are places where 1557 overlaps with and can enforce parts of the Americans with Disabilities Act and draw some of its power from the Americans with Disabilities Act, specifically Section 504 of it. But there are other portions of the law that we need to bear in mind to comply with this fully, specifically your state laws that might be different. And other laws that will take effect, such as, for example, for payers and providers, there might be state-specific discrimination provisions, and there might be requirements in terms of covered services for insurance companies or that providers have to cover. This is something that gets updated periodically on a political level with your state legislature or by regulators setting regulations in terms of what kind of services have to be covered. And there is some overlap between those topics and the anti-discrimination topics we're talking about today. The operative language of Section 1557 talks about the scope of discrimination that's prohibited. Specifically, it provides that an individual shall not, on the basis of race, color, national origin, sex, age, or disability, be excluded from participation in or be denied the benefits of or be subjected to discrimination under any health program or activity, any part of which is receiving federal financial assistance. So this definition of federal financial assistance, you'll see it abbreviated as FFA in this presentation. It's very broad. It goes beyond just receiving Medicare funds or Medicaid funds. It's a more inclusive standard than what you would be looking at from a compliance standpoint from the anti-kickback statute or Stark Law, where you would be looking for federal funds that are directly paid or can be traced back to it. This is anybody that kind of coats on the tails of receiving that without respect to referrals or any kind of financial relationships. If, for example, certain subcontractors, billing companies, other providers that are kind of drafting in the wake of receiving benefits that are in part paid for by federal financial assistance, not just the Medicare or Medicaid program. So obviously TRICARE would be implemented. Certain other federal benefits, for example, the Department of Labor's EOCPA program for energy workers, that would be implicated here because that is federal financial assistance, even if it's not a traditional payer program like Medicaid or Medicare, that would be implicated here. So the swath here is to affect a larger part of the healthcare economy. So the brief history here is that in 2010, Section 1557 became law as part of the Affordable Care Act. And there was the original rulemaking that was conducted in 2016. Now, we mentioned that earlier. It had to do with accessibility and making sure that information was made available to participants. That's where the origin of the signs and the postings in numerous different languages, specifically 15 of them that are most frequently available within your geography, became what was required by HHS. A lot of that was rolled back in 2020 with the Trump administration revising the rules with respect to 2020. And then there was a Supreme Court decision that addressed the scope of what discrimination was covered or not covered within 1557, and that was issued in August of 2020. Thereafter, there was a change of administrations. The Biden administration issued new interpretation based on that Supreme Court decision. And then in 2022, most significantly for the purposes of some of our discussion today, the Biden administration issued guidance from the Office for Civil Rights, which is the office within the Department of Health and Human Services that enforces Section 1557 the same way that they enforce HIPAA for privacy violations. That office issued some guidance regarding the availability and applicability of gender-affirming care, and we'll talk about that a little bit later. Thereafter, the Biden administration issued a more sweeping rule that was the subject of some webinars that we did last year to get people prepared for it. There has been some litigation over that, and certain jurisdictions' implementation of the rule has been stayed. It's generally within jurisdictions, not within our footprint. A lot of litigation happened in courts that are generally more favorable to these kind of legal challenges to the kind of rules that were being promulgated by the Biden administration, specifically in places like Texas, Mississippi, and Florida. And as a result of that, there was a bit of a chessboard in terms of what the implementation deadlines were and when and where that was going to be the effect. But for the most part, the Biden rules took effect, and then there was a rescission of portions of them within February of 2025. What's significant about that, however, is that there was a lot of wholesale revocation of rules that were implemented by the Biden administration that affirmatively furthered diversity, equity, and inclusion. A very prominent example of that being rules that were implemented by the Securities and Exchange Commission to require those kind of emphases in annual reports and to be integrated in companies' businesses. That was something that was an immediate target by the current administration, whereas the rulemaking under 1557 was not. What's likely the best explanation for that is that 1557 just imports the standards and requirements under the Civil Rights Act into the healthcare space for anybody that's receiving federal financial assistance, and basically applies existing law in a way that discrimination is not permitted. And from a standpoint of whatever goals, whatever emphasis one party or the other would like to place on anti-discrimination, that is something that is not something that is going to be easily removed from or removed at all from the ecosystem. It's very much the law of the land, whereas taking affirmative steps to rectify historical wrongs or prioritize certain goals through diversity, equity, and inclusion is something that's a step beyond just mere non-discrimination. So those rules outside of the healthcare space were a more inviting target and could be more easily addressed through executive action versus a full rulemaking process or legislative action. So for that reason, given the scope and how the 1557 rulemaking in 24 was done and what the scope of it was, I and many others were watching and expecting to see some kind of action from the Trump administration. We have not seen it, but looking at the way that the rulemaking was done in 24, how it's just importing existing legal standards rather than creating new ones. It makes sense that that hasn't happened, but for the rescission of the 2022 guidance that we'll talk about shortly. So going back to our discussion here, entities that have to comply with 1557 that are receiving FFA, they're called covered entities. It's a very common term for OCR. It's the same language from HIPAA. A good rule of thumb, although not axiomatic, is that a company that is, or an entity that is going to be a covered entity under HIPAA will end up being a covered entity under 1557. It's a different standard. It's a different analogy. It's a different standard. There's different criteria for it. But by way of thinking about it using the same terms that are being used by OCR across the two different bodies of law, looking at it in terms of being a covered entity for one purpose is a indication that you might be a covered entity for the other purpose. So if there's an entity that's receiving federal funds or federal assistance and it is a covered entity under Section 1557, it likely is engaged in the kind of conduct that would make it a covered entity under HIPAA. Not a guarantee, but it tends to be a leading indicator as to whether some more investigation is necessary, and the obligations tend to travel together. Examples of entities that exchange or receive FFA, some of the ones that we talked about here: hospitals, health clinics, practitioner groups, pharmacies, PBMs, other payer entities, third-party administrators that administer group plans, or administrators for Medicare organizations such as Medicare managed care organizations. And then other entities that exchange or receive Medicare B funds that could potentially extend to subcontractors of any of those companies. So some of the subcontractors that could apply to, for example, would pertain to some of the subcontractors would be, for example, billing companies, management services organizations, and other entities that are involved with providing, for example, labs or any other services that are paid for whole or in part by these kind of federal funds that trigger the FFA obligation and create a covered entity. So for a roadmap, some of the points about compliance with Section 1557 are subject to these kind of catch-all slides to show you where we are and what the issues are going to be. So one of the requirements imposed by Section 1557 is the requirement to submit an assurance form to OCR to certify compliance with Section 1557. There are certain other requirements that mirror the obligations of the Americans with Disabilities Act that apply to companies with 15 or more employees. And then there are other policies and procedures components we'll talk about thereafter. But starting at the foundation, what is necessary to comply with 1557? The first is to certify your compliance with OCR. So when applying for federal financial assistance, the entity has to promise that its health programs and activities will be operated by entities operated in compliance with Section 1557 and the applicable regulations. There's an HHS assurance form for that purpose, and then after submitting the form, the covered entity has to incorporate the promise into its subsequent FFA request. This is similar to the claim component of the False Claims Act that many of you will hopefully be familiar with when submitting claims for reimbursement to the federal government, the obligation that any statements made within it have to be true and accurate. And there's also the theory of the implied negative false claim, where if something is inaccurate, making the claim to the contrary and submitting the form stating that you're in compliance with all federal laws and there are no improper or prohibited transactions underlying the services and they can all be lawfully paid. That's the implied false claim stating that, well, I'm in compliance with the law, and when there's actually non-compliance behind the scenes. So that is the purpose of that, and it's the same general concept for these recertifications when seeking federal financial assistance. Moving to entities that have 15 or more employees, there's a 1557 coordinator that has to be appointed. This is similar to the obligation under HIPAA to create a privacy officer, or for companies this large, there's likely a person with enough terminal authority, if not a full HR department, where there can be somebody that is given this task and be responsible for shepherding compliance with it. The standard for doing this when there are 15 or more employees is to designate at least one employee as the Section 1557 coordinator to ensure compliance. The responsibilities on behalf of the covered entity include handling grievances, ensuring compliance with record-keeping requirements. We'll talk about that in a moment. Coordinating effective implementation of language access procedures. We talked about that a little bit before about the requirement for all the important postings to be available in numerous different languages that are spoken in the community and the population that's served. And then also maintaining documentation and coordinating the training for relevant employees. How is this done? There are policies and procedures that have to be maintained. Specifically, there are 5 main bodies of them: a non-discrimination policy, grievance procedures, language access procedures, effective communication procedures, and reasonable modification procedures. Anybody familiar with HR or that has a legal background that's more broad, that they've looked at the ADA in the past, will recognize some of this language as having significant overlap with the ADA, and they do tend to look at one another with coming up with these requirements. So generally, compliance with the relevant portions of the ADA will prime one for compliance with these obligations. However, it's important to treat them separately and make sure that, to the extent that 1557 is separately monitored for compliance with by OCR within HHS, that documentation exists and can be provided to OCR if needed. For all policies and procedures for all covered entities, the policy procedures must be written. It's a common issue where these obligations come up and somebody's having a breach situation, or they're concerned they have a breach situation. The first thing I ask for is their policies and procedures. I get something like an employee handbook, or being told they're not in writing, or seeing some of this general printouts of the general rule. Very important to have policies and procedures, very important to go through the expense of doing that and keeping them segregated. So if you have a moment where there is a complaint that goes to OCR, or if there's ever a need for an audit, those policies and procedures exist. They're segregated into a separate written electronic document or prior versions of it to track what the versions are. It's a little aspirational. That can be difficult for organizations depending on their size and complexity. But at minimum, they need to be printed and ideally with a digital copy maintained in another location so they can be presented where needed. There should be an effective date. When adopting policies and procedures, there should be a global effective date for all of them. As updated, each policy and procedure should receive a last updated date to indicate when the latest version of it became effective. And then much like HIPAA and its policies and procedure requirement, the policies and procedures have to be reasonably designed to take into account the size, complexity, and type of the organization. An organization that's providing services in infectious disease or for outpatient renal dialysis treatment is going to be very different from an OBGYN clinic or a birthing center or a surgical center or a hospital, or as we're seeing in Nevada where I'm located, increasingly the focus on having pediatric centers or entire freestanding pediatric hospitals, and those requirements will be different from organization to organization. That doesn't mean that they're going to look markedly different from organization to organization, but there has to be some consideration for what the operational realities and challenges will be across organizational types. Finally, the policies and procedures have to be implemented and have to be complied with. So what does compliance and implementation look like? At minimum, the non-discrimination policy has to confirm that there is not discrimination on the basis of race, color, national origin, sex. Different states look at this differently in addition to the federal standard that includes gender identity and expression, sexual orientation, and other characteristics and traits. Pregnancy and related conditions are generally considered to be part of a sexual identity or sexual orientation as well. Certain states have different standards that go above and beyond this as well. They should be considered additionally. I know that certain states have adopted the trend where someone's physical appearance is considered for non-discriminational purposes as well. There should be language assistance services for people with limited English proficiency. We have a number of slides about that at the end. We'll turn back to that later. And there have to be reasonable modifications for individuals with disabilities and the contact information for the Section 1557 coordinator if the organization is large enough to require one. The policies and procedures have to provide for prompt and equitable resolution of grievances, alleging that any action would be prohibited by Section 1557. So what would that mean? If there's a type of service that would not be available to somebody on the basis of sex and solely on that basis, that is generally what this would look for. For example, there is a piece of litigation that was ultimately dismissed by the United States Supreme Court. It had to do with individuals that sued anonymously as John Doe sued CVS, alleging that CVS's requirement that they would receive certain medication that was frequently used by people who had contracted HIV was only going to be available from physical pharmacists and not mail order pharmacies. And the reason that the people alleged that that would be potentially discriminatory on the basis of sex is that it was highly tied to their sexual orientation and the ability to seek that treatment from a mail order pharmacy, even though there was no requirement that they would have to go in and obtain it from a physical pharmacist. They had already received the prescription from a physician. They alleged that it was potentially discriminatory and forced them to have in-person interactions that would potentially violate their anonymity or force them to face potential discrimination by other customers or for pharmacists that might have judged them for their medical condition. So that's an example of what ended up being considered, at least to a level that it reached the Supreme Court, of what would be considered discrimination on the basis of sex, or in that case, what was alleged to be a sex-based trait, namely sexual orientation. So there's a couple of places where that would potentially show up. It's going to vary differently. For example, there are medical reasons why somebody might not be eligible for one treatment or another. There are sex-specific reasons why men and women would not necessarily receive the same care or be ineligible for care from certain care providers. For example, obstetric and birthing services. Generally follow along one line in terms of the birthing person. But for other reasons that are medically necessary, there can be a non-discriminatory reason for providing it. The main issue is when providing these services and getting into a situation where somebody might allege discrimination, being able to identify what that non-discriminatory purpose is and being prepared for the fact that there may be other avenues of potential discrimination that are alleged, such as the example provided a few months ago about Doe's versus CVS. Finally, it's important to retain the records of any kind of grievance that are filed so that the entity can demonstrate its compliance in case there's a escalation of the grievance to OCR, and OCR needs to confirm that the entity did comply with its obligations under 1557. The records that have to be maintained include the grievance itself, the date of the grievance, the name and the contact information for the complainant, what the alleged discrimination was, the date of the resolution, and what the form of the resolution was, and all of the pertinent information. Much like record keeping in a medical institution, if there's an anticipation of dispute with the patient or dispute over payment, for example, if something that winds up being a very complicated case initially presents like it shouldn't be, it's all the more important to document the various things that indicate that it's a higher severity, a more complicated case than it initially appeared to be. The same is true here. The more documentation that exists to demonstrate the efforts that were undertaken to resolve the claim of discrimination, the better, and the more it demonstrates the covered entity's efforts to comply with the applicable law. The procedures that have to be adopted include, at a minimum, description of the process for providing language assistance services to people with limited English proficiency, commonly abbreviated as LEP or LEP. Current contact information for the Section 1557 coordinator if one exists. How an employee identifies whether an individual has limited English proficiency, such as asking for that person's feedback or trying to communicate with them in English. Identify the measures for how an employee would obtain the services of qualified interpreters and translator the covered entity would use to communicate with the individual that has LEP. That's discussed later in this presentation. The names of any qualified bilingual staff members and a list of electronic and written translated materials that the covered entity has, the language that they're translated to, the dates that they were issued, and how they can be accessed by the covered entity. Additionally, procedures have to have measures for effective communication, describes the process for ensuring that there is effective communication for the individuals with disabilities when required by regulation, current contact information for the Section 1557 coordinator, identification of how the employee obtains the services of qualified employers that are qualified interpreters that are used by the covered entity, the names of qualified bilingual staff members, and a description of how to access the appropriate auxiliary aids and services, whether that might be an iPad that's used for translation services. I've been in situations not in the healthcare setting, but in certain circumstances where it's helpful to pass a phone back and forth using a service like Google Translate. Obviously, something that would be HIPAA protected or an institutional device that is not widely available to the internet and only used by the institution would be preferable for those circumstances for data privacy reasons. But there are tools that can be used to ameliorate this concern and rectify the need to communicate with patients on a protected basis. Finally, much like the ADA, there's a requirement for reasonable modification. Under the ADA, this is often referred to as reasonable accommodation. There has to be a written description of the process for making a reasonable modification to the policies, practices, and procedures when necessary to avoid discrimination on the basis of a disability as required by regulation. Additionally, there must be a description of the process for responding to requests from individuals for changes, exemptions, or adjustments to rules and policies, and a description of the process for determining whether making the modification would fundamentally alter the nature of the health program or activity. For example, if somebody needs to have a metal device with them for an orthopedic or other need, that's not going to work in an MRI imaging center. So there's a need to think about and document when the accommodation that's requested is impossible. Individuals with backgrounds in human resources or employment law will understand that sometimes the accommodation that somebody wants is completely inimical to the nature of the job and they need to be rehomed or that relationship needs to end, such as if somebody has a debilitating physical injury and they can't return to their work working in, for example, a warehouse or a very physically demanding job. In the same way that sometimes a condition or someone's disability will be such that it's fundamentally at odds with the nature of the condition, the nature of the treatment that needs to be rendered. So sticking with the imaging idea, there are options for open-sided MRIs. There are ways to look at that. Sometimes the patient might need to be referred to another facility or referred out entirely. However, sometimes if the condition is something where they're just in a position where they cannot qualify for the MRI for reasons that involve metals and magnetism, just to stick with the same analogy, that is something where even the accommodation of an open-sided MRI would not be able to accommodate the patient's disability and make that service reasonably available to them. Moving on to training, something that also has shades of HIPAA to it. Employee training is something that must be done for all relevant employees and based on the organization's specific 1557 policies and procedures. It's important to document the completion of the training. And what is recommended here is to document not only the training materials and to keep them, including prior versions, for at least a period of 3 calendar years. It's also recommended to maintain proof of what the compliance was. For larger organizations that have knowledge tracking materials and have learning paths that can track the compliance, those records should be kept for 3 years, including the underlying slides, certificates of completion, and any other kind of metadata, such as showing when the person began, attended, and when they concluded and successfully completed their completion of the learning modules. This can also be done in a way where, for example, if people are tested on materials, any kind of retest, the results of the tests can also be stored, and a number of third-party vendors provide that information. It's also important, though, to look if there's a change in vendors or if that relationship ends, to make sure that you retain copies of the data and keep ownership of it, which can sometimes be a discussion point at the end of that relationship. The definition of relevant employees that have to be trained generally would involve anybody that's going to be patient-facing. So the training might be different from position to position. For example, somebody in the financial office might need a different form of training to talk about how discrimination can manifest in the application of payments, or if people are being denied certain services, or if some financial aspect of the relationship with the practice is impacted by their disability, or that it can't be discriminated against, such as, for example, if people from a certain background bank with a certain bank, or if they seek to make payments in certain ways, such as check or money order versus credit or a debit card for their co-payment obligations. The training for that would be different than dealing with frontline medical personnel that have a more conventional training of what we would think about in terms of discrimination that can occur or could potentially occur between a provider or frontline staff that interact with patients and the patients themselves that might be susceptible to discrimination based on age, race, national origin, sex, or some other protected characteristic. And the focus of this definition of relevant employee are the ones that make decisions that either directly or indirectly affect patients' health care, and the ones that perform tasks and make decisions that directly or indirectly affect patients' financial obligations, including billing and collections. So that's the reason for the discussion of back office staff and how their decisions could potentially result in some claim of discrimination by a patient who's affected. And finally, the last point, when in doubt, you can train everybody, but if your resources allow it, it's helpful to tailor the training so that the issues and the instances of potential discrimination are identified based on the employee's function to the extent possible. So back when this rule was first implemented, there was a time to phase this in. We are past that point. As of July 1st of this year, everybody should be trained. For new employees that come on as part of the onboarding, especially with large companies and especially with any individual practitioners that come on that are healthcare providers, there's often a lot of onboarding training that is done. From HIPAA and other standpoints, this can ideally be made part of that process. There's a frequency requirement, much like the reasonableness requirements in terms of what needs to be in the policies and procedures for compliance with Section 1557 and HIPAA's privacy rule. What is appropriate frequency should be at least annually, but sometimes more frequent training is beneficial, such as, for example, if there's a change in regulation, if there's a change in your policy procedure, or if there's an incident in response to that, there's remedial training that is helpful to do on an ongoing basis. HHS recommends that this training happen as frequently as possible, just based on its observation that the more often the training occurs, the lower the incidence is in breaches for HIPAA, applying the same analogy where the more frequently somebody is trained, the less likely there is that there's going to be any kind of breach that's caused, at least from employee inattention or negligence, as opposed to outside threat actors, which also can be prevented by employee diligence and vigilance in protecting themselves against phishing schemes and things of that nature. So that's why it's significant to go through that, and the data set that HHS has based on HIPAA responses and HIPAA training is very relevant to determining its recommendation as to how often training should occur under Section 5057. In terms of going through compliance, the non-discrimination notices and the availability of language assistance services and auxiliary aids is something that needs to be communicated and prominently posted to all potential patients and individuals that are going to be receiving services from the covered entity. The notice of non-discrimination is, like we discussed earlier, something that's come back and forth. It was originally something that was going to be implemented in the 2016 rulemaking, and it continues on to this day. The notice has to be provided to participants, often as part of a onboarding package, and updated annually or provided upon request, similar to a notice of HIPAA privacy practices. So a lot of the same elements that you would expect to see from HIPAA policies and procedures will also apply here, just largely due to the fact that it's the same enforcement arm, and that enforcement arm is largely informed by its experience enforcing HIPAA. The requirements for the notice of non-discrimination are identified here. Generally, it has to disclaim any kind of discrimination on the basis of race, color, national origin, limited English proficiency, sex, age, or disability, that the covered entity provides reasonable modifications for individuals that do have disability, including appropriate auxiliary aids and services and interpreters where necessary, that there's language assistance available to individuals with limited English proficiency, including electronic and written transcribed documents, description of how to obtain the reasonable modifications, the contact information for the Section 1557 coordinator if one exists, the availability of the grievance procedure under Section 1557, information about how to file a claim of discrimination with HHS and the OCR, and then finally how to access the covered entity's website that provides the contents of the notice. And there's a further notice about how the notice has to be provided to participants, beneficiaries, enrollees, and applicants. Specifically, the notice has to be provided in English in at least the 15 languages most commonly spoken by individuals with limited English proficiency in the states where the covered entity operates. For entities with operations in numerous states, it might be a best practice to identify a packet on a state-by-state basis. This is an area where HHS does have good resources available, and they have not all been removed from the website. So depending on the language that's necessary, even querying Google or going to the HHS OCR website and using the search function there can be useful for finding these and not having to engage in translators yourself and figure out by demographic what are the 15 most commonly spoken languages in the state where it's going to be operating, even if all the operations are within one state or if they're spread across numerous states, and having an appropriate package of disclaimers in all the applicable languages for those states. These will have to be periodically updated. OCR does periodically update these statements, or at least the English language version should be updated to demonstrate compliance to the greatest degree possible. And then there should be additional communication along with this, along with the notice of privacy practices required by HIPAA, notices of denial and termination of eligibility, other forms and papers that are provided by the practice, and other communications regarding the individual's rights, eligibility benefits, or services that require response by the patient. Language assistance services are a major linchpin of Section 1557 of the 2024 rulemaking, and something that people paid a lot of attention to. So the notice requirements regarding the auxiliary aids, we will talk in a little bit about how to actually comply with that and provide these kind of services. But the covered entity has to provide notice that the individual can opt out of the notice, but they have to provide the notice in the primary language through an appropriate auxiliary aid. They cannot condition receipt of any aid or benefit on the decision to opt out, which seems like it should be fairly obvious, but it's a recurring question. The notice must inform the individual of their right to request the notice in their primary language and through appropriate auxiliary aids and services, and their right to receive the language assistance services and appropriate auxiliary aids. The opt-out has to be documented on an annual basis, and then opt-out has to be affirmative. It can't just be a non-response. There has to be an affirmative act to specifically opt out of the notice requirement for individuals who have limited English proficiency or that require assistance. Moving on to the non-discrimination requirements, this goes into the elements that are necessary to not discriminate and to document and ensure compliance with Section 1557, namely through providing meaningful access for individuals that have limited English proficiency, providing the effective communication, information, and communication technology for all individuals, including those with disabilities, ensuring that buildings and facilities are accessible to all, something that is previously addressed in the Americans with Disabilities Act and might be addressed by state law in your state. Providing equal program access on the basis of sex, which is an issue that has triggered some controversy that we talked about a little bit before, and we'll get into a moment here. And then to ensure patient care decision support tools and telehealth are used in a non-discriminatory manner, which has some components that we'll talk about here. Here we have the HHS interpretation of the discrimination prohibition in general. It states that except as provided in Title I of the ACA, an individual must not, on the basis of race, color, national origin, sex, disability, or any combination thereof, be excluded from participation in or denied the benefits of, or otherwise subjected to discrimination under any health program or activity operated by a covered entity. So what does that actually mean, and what does that get us into? Well, on the basis of discrimination by sex, HHS interprets this to include, but not be limited to, discrimination on the basis of sex characteristics, including intersex traits, pregnancy or related conditions, sexual orientation, gender identity, and sex-specific stereotypes. This is also a relevant component for health insurance. As of this year, any policy that was not yet in compliance with this, or a policy that previously existed that needed to be brought into compliance, beginning this year, these plans needed to make sure that they could not deny, cancel, limit, or refuse to issue or renew health insurance or another health-related insurance coverage, for example, vision, dental, or other incidental benefits, or deny or limit coverage of a claim, impose additional cost sharing, or put other limitations or restrictions on coverage on the basis of the protected classes that we talked about there. Moreover, this extends to marketing practices so that there cannot be any marketing practices that discriminate on the basis of race, color, national origin, sex, disability, or any combination thereof. That can be in a way such as making sure that the marketing does not exclude certain communities or is only done in certain communities at the exclusion of others that would normally participate in or benefit from those services. Moving on to providing meaningful access to individuals with limited English proficiency. Covered entity must take reasonable steps to provide meaningful access to each individual and their companions with limited English proficiency eligible to receive or likely to be directly affected by the covered entity's health programs and activities. So what does this mean about the companions? Often, especially in communities where people do not speak English as the primary language, the person that is most proficient will be designated as the family's translator, regardless of their proficiency in English. It's a situation where the person who is most qualified is often the designee for these services and will be required to provide them. So what will be useful there is to make sure that the individual that's going to be providing those services for the family member, whether it's a spouse or a son or even a grandchild, is able to attest to their abilities and communicate effectively, not just with the family member that they're accompanying, or it could be, for example, a romantic partner, but to make sure that the relationship is understood and that the translation is accurate and effective to the best of the knowledge of the healthcare provider. There's a better regulatory definition of companion here, along with what we described, meaning a family member, friend, or associate of an individual seeking access to a service who, along with the individual, is an appropriate person to whom a covered entity should communicate. This does implicate HIPAA as well. The individual patient does need to confirm and may need to confirm in writing that this individual is somebody that they are willing and able to designate as their companion to receive that information with them, whether at the time of the appointment, visit, or interaction, or at some other point in the future. There's also a definition for what constitutes an individual with limited English proficiency. It's defined as an individual whose primary language for communication is not English and has a limited ability to read, write, speak, or understand English. An individual with limited English proficiency may be competent in English for certain types of communication, but still be limited English proficient for other purposes. This differentiation between somebody may have a great understanding of English as a spoken language, but would not be able to communicate effectively in writing, whether in the form of reading or writing in the English language. There are other undefined terms here, though. Largely to retain some regulatory discretion, HHS declined to define what constitutes reasonable steps or meaningful access, even though this was requested by many commentators and when this went through the notice and comment period under the Federal Administrative Procedures Act and the finalization of this rule. Generally, though, to fulfill the requirement of taking reasonable steps to provide meaningful access, language assistance services must be provided free of charge to the patient. They must be accurate. They must be timely. It cannot be a requirement that somebody has to wait 4 hours for the translator to show up. They don't necessarily have to be certified translators, but there can't be any questions about the accuracy of the quality of the translation. And moreover, the translator should be in a position to sign a business associate agreement with whatever the provider group or the providing entity, such as a hospital or a surgery center, in order to protect the privacy of the patient information, since they will be exposed to PHI, and also to memorialize, likely in a separate contract, that they will not interfere with or try to bear upon the independent decision-making of the ability for whom they are translating. And some examples of the language assistance services can include in-person remote oral language assistance by a qualified interpreter. Again, does not say certified, just qualified. Your state might have requirements for interpreter certifications, but somebody that's qualified can just be somebody that's known to the practice and their qualities and credentials are documented and not in reasonable dispute. There can be paper or electronic translations performed by a qualified interpreter, going back to the example about using Google Translate or similar services to facilitate that, bearing in mind that there should be some kind of technical safeguards to protect the safety and privacy of the information that's being entered into that format. And then a written notice of availability of language assistance services so that an individual or their companion, if they do have limited English proficiency, will be able to identify in their primary language that these services are available so they know to ask for them. There are specific requirements and restrictions for providing this access, namely specific requirements related to interpreter translation services. It has to be a qualified interpreter required, a qualified translator when required, and then there should be a qualified human translator review AI-generated information when the underlying text is critical to the rights, benefits, or meaningful access of an individual with limited English proficiency. Going to the example of Google Translate, that can be effective, but it's limited just because it's a general purpose translation app. For anything that would be important, such as major decisions to commence certain medications, such as controlled substances like opioids, to go forward with surgery, to undertake other significant episodes of care, a human should be involved at that point. For general conversation, getting certain information, a background basis, a translation app can be useful for that, but for more critical decisions where there's a higher risk to the provider of a potential claim, or for something that would be material to the patient's outcome, human involvement is required and necessary due to the importance of accuracy of the translations there. Qualified interpreter generally means somebody who adheres to generally accepted interpreter ethics and principles, including confidentiality, is able to interpret effectively, and has demonstrated proficiency in writing and understanding both written and at least one other non-English language. So if there's any questions about whether an individual interpreter or interpretation service would qualify, again, subject to any different standards that are set by your state law, there is the federal regulation that gets into this issue. It's at 45 CFR 92.4. That citation is provided at the bottom of the slide. Another option is relay interpretation. It means interpreting from one language to another through an intermediate language. This can happen sometimes with lesser known dialects. This is something that happens increasingly in courts and recently happened in my home jurisdiction in Clark County, Nevada, where Las Vegas is based, where there was an unfortunate issue where there was a legal proceeding in court that was delayed by days, if not weeks, to identify translators that had appropriate familiarity with a very specific dialect of one of the people that were impacted in the proceeding, and what was necessary was ultimately going through a series of translator where somebody was able to translate from the relevant dialect into another language and then from that language into English. So this is a common scenario. Hopefully it doesn't happen too often just because of the necessary logistics and delay that it can impose upon a patient, but it is something that's contemplated in the rules because of the frequency with which it occurs. And the second bullet, it identifies that in relay interpreting, the first interpreter listens to the speaker and renders the message in the intermediate language, and then the interpreter receives the message in the intermediate language and interprets in the third language for the speaker, who speaks neither the first nor the second language. That might end up being English in those circumstances. Certain things that cannot be done. Requiring an individual to provide their own interpreter or for the pay the cost of their own interpreter. Unfortunately, this is something that has to be a cost of doing business. Additionally, while a family member can provide interpretation services, it cannot be relied on a minor child to interpret or facilitate communication. This can be done as a temporary measure while finding a qualified interpreter, but it is not something that can be imposed upon the minor. While adult children are welcome to participate and can satisfy this role, except for intermediate measures, a minor should not be relied upon to provide these translation services. Additionally, Additionally, staff other than qualified interpreters, qualified translators, or qualified multilingual staff to communicate with individuals with limited English proficiency cannot be relied upon. This invites potential miscommunications, misdiagnoses, and other problems that can result in bad outcomes for the patient and also can result in problems for the provider as well. Again, the definition of a qualified translator, we had discussed this and it's in the prior slides, but it's important to discuss here. A qualified translator is somebody that has demonstrated proficiency in spoken and written non-English languages in addition to English and is able to translate effectively, accurately, and impartially to and from such languages using any specialized vocabulary or terms without changes, which is significant in the medical diet, the medical context, just because these terms might not be in common use, even from family members that are able to provide those services. And somebody that is trained in will adhere to generally accepted interpreter ethics and related principles. So qualified bilingual or multilingual staff can provide some communication with these individuals, but still an interpreter, and a qualified interpreter will be the gold standard. There is some regulatory guidance in terms of what qualifies as qualified bilingual or multilingual staff. It's a member of the covered entity's workforce that is designated by the covered entity to provide in-language oral language assistant as part of the person's current assigned job responsibilities and who has demonstrated proficiency in speaking and understanding both spoken English and at least one other language and is able to effectively, accurately, and partially communicate directly with the individuals. The reason why this is so significant is it has to be within the scope of the person's job. It is not something that can just be assigned to somebody and be a ad hoc expansion of their job obligations. This is something that needs to be part of, even if not in great extent, but at least part of their job duties. Ideally, it would be documented in an employment agreement, an offer letter, or some kind of addenda there too that the person would sign if this is something that's discovered later in the course of their employment or other relationship with the facility or other covered entity, to identify that this person does have this ability and agrees to provide it, just in case there's any kind of issue or complaint and you have to go back and prove compliance. That you don't want there to be a situation where somebody was designated as qualified bilingual or multilingual staff, and they may qualify in all ways, but if it can't be documented in some way with a offer letter, an employment agreement, or some other kind of document that's executed at the beginning of or during the course of employment that is not thereafter terminated, repudiated, or made ineffective, that would demonstrate that they have these qualifications and agrees to do these services in the course of their employment. Similarly, there's other restrictions on what covered entities cannot do. They cannot rely on an adult who is not a qualified interpreter to interpret or facilitate communication, except somebody with the minors to act as an intermediary while a qualified interpreter is found, and also where the individual with limited English proficiency specifically requests in private with a qualified interpreter present and without the accompanying adult present, that the accompanying adult interpret or facilitate communication and the accompanying adult agrees to provide such assistance. So there is a way through the use of a potential interpreter to allow for the other adult attending to provide this kind of interpretative service, but this has to be done without the other person present and with the interpreter being the one to determine that that is the request of the individual. Special consideration for remote use of a qualified interpreter. If the covered entity provides qualified interpretation services through video remote interpreting services, the covered entity must ensure the modality allows for meaningful access, such as simultaneous audio-visual use, not asynchronous audio use, such as exchanging voice notes. There's more guidance about this, specifically requiring that real-time full-motion video and audio is done over a high-speed, wide bandwidth video connection. The image has to be as large as possible to display the interpreter and the participating person's face regarding the person's body position. This is to allow if individuals rely on lip reading or better understand the language if they're allowed to read the lips of the person that's speaking as well. There has to be clear audible transmission of voices and adequate training of the users of the technology so that they may quickly and efficiently set up and use the remote operating services, the remote interpreting services, rather than trying to set this up over a long period of time or having the patient suffer further delay. And moving on to providing effective communication, information, and communication technology for individuals with disabilities. There's some technical provisions that relate to this. First and foremost, a disability is a physical or mental impairment that substantially limits one or more major life activities. There's a record of that impairment for that individual, and it's regarded as having, and the individual is regarded as having that impairment as construed in the Rehabilitation Act. For communicating with individuals who have disabilities, it's important to take appropriate steps to ensure that the communications are as effective as communications with non-disabled persons, and that includes providing auxiliary aids and services where necessary to afford individuals with disabilities an equal opportunity to participate in, enjoy the benefits of the health program or activity. Like the interpretation services, the auxiliary aids and services have to be provided free of charge in accessible formats that the patient can use, not just what the practice would deem effective, and in a timely manner, in a way that protects the privacy and independence of the individual with disability. Once again, if an outside service is being used that might access, use, or retain any of this kind of information that's specific to the patient and their health treatment, a business associate agreement should be present. Some examples about what would constitute auxiliary aids and services. Rather than delineate what they were specifically, HHS provided some general examples for ease of reference. Namely, that would be the use of qualified interpreters on site or through video remote interpreting services, note takers, computer-aided transcription services, assisted learning system, listening systems, and other equally effective telecommunications devices or other methods like that. Additionally, qualified readers, tape text, audio recording, braille materials, screen reader software, magnification software, optical readers, secondary auditory programs, and large print materials are all ways that can be done to comply with this. For example, it's built into a lot of technology. Some of you may have seen individuals increasing the size of the text that is used in text messages and emails on their phone, or in protocols such as Outlook. Occasionally I'll receive materials with much larger text size than I personally use. I assume it's for that person's ease of reading and eliminate or alleviate any kind of strain in their eyesight to make sure they can clearly follow along with the content of the email. Similar to the interpretation qualifications that we talked about earlier, a qualified interpreter for an individual with disability is an interpreter who, whether on-site or through remote interpreting service, demonstrates the proficiency in communicating with a language other than a foreign language, specifically American Sign Language or other sign language, and then another communication modality such as cue language translators or oral transliteration such as lip reading. This ensures that the interpreter for the disabled person can interpret effectively, accurately, and impartially, both receptively and expressively, using any necessary specialized vocabulary or terms without changes, which is very important in the medical context as we've discussed, and without omitting or adding any information while preserving the tone, sentiment, and emotional level of the original statement, often by the practitioner or by the patient. Finally, this person must adhere to generally accepted interpreter ethics principles. Certain restrictions on what a covered entity can do. First of all, the covered entity cannot require an individual with disability to bring their own interpreter with them and cannot rely on an adult accompanying an individual with disability to interpret or facilitate except in an emergency, or with the person with disability specifically request that the accompanying adult interpreter facilitate communication, similar to the test used before where that request has to be made outside of the presence of that adult, but with the use of an interpreter. And similar to the limited English proficiency standards that we discussed a moment ago, the individual with the disability and the covered entity cannot rely on a minor child to interpret or facilitate communication except in emergency circumstances where there's an imminent threat to safety or imminent threat of safety or a threat to welfare of an individual or the public, and there's no interpreter available. A classic example of these kind of aids would be TTY, text telephones. If a covered entity communicates with patients via telephone, TTY or other systems must be used to communicate with the individuals. If a covered entity uses an automated attendance system, such as voicemail messaging or an interactive voice response system, there has to be an option for an individual to connect on TTY or some other kind of FCC-approved service that would accommodate them and not force them to use the phone system that would not be accommodating of their disability. And then finally, the covered entity has to respond to telephone calls from a telecommunications relay service established under Title IV of the ADA in the same manner it responds to other telephone calls. That pertains to inbound TTY and similar telephone calls. For individuals that do have disabilities, to satisfy the obligation for effective communication, the covered entity must make sure that the individuals can obtain information as the existence and location of the services that are available to them, and even at inaccessible entrances, provide direction to users of where the location of an accessible entrance is, and direct them to that place, and post the international symbol for accessibility at each accessible entrance. So not only identifying where the individuals can go, but if they reach an inaccessible location, direct them to where the correct location that is most accessible to them would be. Now, finally, there's a requirement for IT accessibility for recipient or state exchanges so that its health programs and activities and mobile applications comply with the obligations of the Rehabilitation Act as interpreted with Title II of the ADA. Well, beyond the scope of this webinar and this call today, there's an increasingly large body of law regarding the internet obligations to comply with the Americans with Disabilities Act. There's been a spate of potential claims and lawsuits against websites for alleged noncompliance with the Americans with Disabilities Act. It's a burgeoning area. A lot of it pertains on the ability to magnify the text and the ability to have it transcribed into text that is read out loud. So it's an audio interaction with the website, but this is an area that is worthy of consideration and mostly pertains in this context to state exchanges for healthcare services. Additionally, a covered entity, this is specific to payers and providers of health insurance, but the health benefit plan design cannot be done in a way that would avoid providing or administering health insurance to individuals that have special needs or are disabled under the Rehabilitation Act or the Americans with Disabilities Act, if the unavailability of those programs would result in some kind of segregation or other institutionalization of the individual. So moving on to buildings and facilities that are accessible, we talked about that a little bit earlier about marking signs to make sure people know where the accessible openings are. A lot of this is already covered by the Americans with Disabilities Act, but generally compliance with the Americans with Disabilities Act design standards will comply with the requirements that are imposed by Section 1557. This is an issue that comes up in facility design for any kind of design build uses. It's also something that can come up and be aggressively negotiated in commercial leasing. But this is a consideration, and in addition to the existing obligations and potential liability under the Americans with Disabilities Act standards, this is now something that is present, and it can be an OCR issue as well. And there's more discussion of this and what is necessary to comply. So moving on to equal program access on the basis of sex, we started this conversation talking about some of the changes that occurred based on the 2024 rulemaking and 2022 guidance that was specific to gender-affirming care. A lot of the focus on this and the consequences of the federal changes in law regarding the availability of pregnancy termination services and the tension between state and federal laws regarding the availability of those services has really fallen outside of the scope of 1557. A lot of this has had to do with the definition of what constitutes discrimination by sex and how that includes sexual orientation and gender identity or expression. So the view of this under the 2024 rulemaking has been that an individual's assigned sex, their sexual expression, their gender identity or genital expression cannot be a basis for denying access to care. There is, however, an exception to that where there was a rescission of part of the guidance that was issued in 2022. The 2022 guidance that was issued by the Department of Health and Human Services indicated that refusing to provide gender-affirming care just on the basis of the person's sex or the sex that they seek, the person's sex or the gender they either identified as or wish to identify as would probably be a violation of Section 1557, and that extended to both adults and minors, consistent with executive orders that were issued at the beginning of the current administration's presidency. Part of that guidance was withdrawn, and specifically as to the delivery of gender-affirming care to minors. So that has been withdrawn. The portion of the March 2, 2022 guidance regarding gender-affirming care was rescinded as it applies to minors. So there is no longer that bright line rule, and providers are able, without violating Section 1557, if they are so inclined to do so based on their conscience or for other reasons, in a uniform manner, decline to provide gender-affirming care to minors. That is also something that's subject to state-specific law, and we require careful analysis of any state obligations with this federal requirement. But the rule has been since the beginning of 25, and probably the most direct action that the current administration has taken regarding 1557 in its rulemaking is to rescind that bit of the March 22 guidance, and specifically as it relates to gender-affirming care for minors. And as we discussed earlier, there could be a legitimate non-discriminatory reason for denying or limiting a service, such as it's not medically necessary, or if it's something that is typically declined or determined that it's not appropriate. 1557 does not automatically override the judgment of a medical provider or entitle the patient to receive whatever kind of treatment that they wish to receive. Similarly, sex discrimination can manifest itself in ways that relate to marital status, parental status, or family status, as specified here, in determining whether an individual satisfies any policy or criterion regarding access to healthcare programs or services. A covered entity must not take an individual's sex into account, applying any rule concerning an individual's current perceived potential or past marital, parental, or family status. So basically, whether somebody is single, divorced, married, a parent, not a parent, a step parent, or living in a blended family, that can't be considered for the purposes of providing health care. Finally, the last step to compliance is ensuring that patient care decision support tools and telehealth services are used in a non-discriminatory manner. Similarly, just like the standards we talked about, these telehealth tools and these other mechanisms can't be discriminated against on the basis of sex, national origin, race, gender, or any of the other elements we talked about, including their disability. And there has to be efforts made to mitigate the risk of discrimination resulting from the tools used in healthcare program services and their activities. The reason this is relevant with the Civil Rights Act standards that have been imported in, where even if there is a non-discriminatory reason to prohibit somebody from using services, if it has a racially discriminatory impact, often known as disparate impact, that could potentially implicate Section 1557. So in terms of making tools available, depending on the tool and how it's used and the way that it's made available to other individuals, it can be important to determine, even if it's not being made available to certain populations, or if it's only being made available on certain criteria, if that has an effect on the population that's using it, that ends up manifesting in a way where people within certain protected classes are or are not using it, that can end up being the basis for a claim of discrimination. Similarly, the use of telehealth has the same obligations for not discriminating or not engaging in any conduct that could result in discrimination in providing telehealth services. This includes audio-only telehealth and asynchronous telehealth services and remote patient monitoring, including the provision of medical devices, tests, and equipment that would be used as part of the health program. So the main issue would be making sure, as we discussed earlier, that even if there are requirements that are imposed in terms of making this available or not making it available, those determinations do not result in a racially disparate impact on the population that needs to use these services. Finally, if there's need for additional help, as I mentioned at the beginning of the webinar, the OCR website is drastically different now than it was in the prior administration, but there are still resources available. The ADA website still exists. Be careful of generalized internet guidance. Every circumstance is different. Small differences make a big difference when dealing with somebody who has a disability versus limited English proficiency. And most importantly, there are state laws that were not covered in the course of this webinar that often will cooperate with the federal laws and regulations here, but do not always work in synchrony with one another and may be different. And it's important to always get a specific response that is tailored to your circumstances and your facts. Since generalized information does not always lead to the correct answer. My contact information is at the end. I'll look now to see if there's any questions. I don't see any questions in chat. We're about 3 minutes past the scheduled end time, so I will hold the line for a few more minutes if anybody has any questions. If there are any, my contact information is available here. Please feel free to email me. I would look forward to speaking with you about any of this, or submit your comments to chat if you have any questions. And I know that these slides will become available on the Health Law blog shortly. Thank you to Luke Kelly for help organizing this, and thank you to all of you for attending for this update and realizing that this is still the law, although the course of enforcing it seems to be changing, but it's still too recent to have any recent data or any kind of recently resolved claims or administrative proceedings to have a clear indication of where the administration intends to take this law that has been with us for some time and looks to be with us for quite some time longer.